Morning, Judge.
Hey, how are you?
Surviving.
It's two. Okay. You are Jorge Estrada.
So,
Mr. Estrada, you're charged with two cases. You're charged with driving while intoxicated. You're also charged with unlawful carrying of a weapon. On the gun case, you're facing up to a year in jail and or a $4,000 fine. On the DWI, you're facing up to 6 months in jail. Looks like you guys have worked out an agreement where they're offering you 6 days in jail with credit for 2 on both of those cases. You need to understand that both of those cases will go on a record. They're going to be there for the rest of your life. You can never take them off. Do you understand? This is important because if you ever get pulled over, officer looks you up. They're going to see all the DWI. They're going to see the gun case. If they roll up to your car and it smells like weed, it smells like alcohol, what do you think they're going to do? Right. What we're doing today, from now on, you are facing a minimum of 90 days in jail. Do you understand? They can use these to enhance your punishment. You're looking at a minimum of 90. How do you plead to the offense? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, like I said, you can never change this. I take it the case upstairs is being dismissed?
yes, sir.
Okay, what about the weapon? Okay, so the weapon will also be forfeited, meaning that you're not going to get it back. You understand?
Yes, sir.
I am going to suspend your license for 90 days.
Would you hear,
Drive until you get a license.
would you hear evidence on the surcharge?
Yes.
Judge, he's 20 years old. He works in a warehouse. He lives with mom and dad. He takes care of mom and dad. He helps pay for rent, pay for things around the house. He's trying to get his life together. His hours fluctuate between 20 and 40 hours a week, 40 on a good week, 20 on a normal week. He's 20 years old, just turned 21 now. 22, I apologize.
How much money do you make a month, sir?
900. Well, I would make 900.
900 every week? You need to understand that DWI is big business in this country. What he's trying to do is he's trying to have me erase around $3,000 worth of surcharges that you would otherwise pay, not to mention court costs of another $400 to $500. So you could potentially be rolling out of here with around $3,500 in court costs. And if you don't pay it, you go to jail 1 day for every $100 you owe. So you could be doing a ton of jail time. You know, we're all allowed to make mistakes in lives, right? But the idea is that you don't continue to make mistakes where you endanger other people's lives. A second DWI, you're looking at surcharges of around $6,000. Do you understand? For $40, one button, an Uber will take you wherever you want to go. It don't matter how many beers, how many shots of tequila, take an Uber. Do you understand? All right, I'll waive it for you.
I agree.
This time,
Yes, sir.
well, that's it. You understand?
Thank you.
All right, good luck.
Thank you.
Thanks, guys.
Good
morning.
I have Mr. Warren here. He went to see pretrial yesterday. He has magistrate's bond conditions. I was just wondering to know if they were sufficient.
Come up, Mr. Warren. What are the bond conditions that we have?
Judge, we have no contact whatsoever with Gracie Patron and Melissa Patron. We also have no drugs and no firearms, weapons, or ammunition.
So the assault is, who's the complaining witness in our assault case?
So on the assault here is Gracie Patron, and then the felon.
You know who that is in relation to this gentleman?
His partner's mother.
Yes, and then the partner is the complainant in the felony.
Okay. You're lucky to be out with as much baggage as you got, Mr. Warren. I mean, your history is just deadly conduct, unlawful carrying of a weapon, assault of a family member, violation of protective order, failure to ID, terroristic threat, violation of protective order, evading arrest, harassment, felony assault, failure to ID, criminal issue, violation of protective order, and now a felony assault and another assault. You're laughing like it's funny. It's it's sad because all of these cases that you have, no self-control. You get angry, you wig out, and that's not the way we work, man. I'm going to protect my community at all costs, Mr. Warren. And if I have to make your bond $2 million, I'm going to do it in a heartbeat to protect my community. Do you understand? You have one issue. I'm going to keep you. That's it. I'm not asking for much, man. Just don't have contact with these people. Self-control. Do you understand? It's not hard. What do you do with yourself these days? Where do you work at? Are you working full time? Great. Like full blown like you're working 40 hours a week?
Yes, sir.
Great. That's good. I mean, I'm making that a bond condition as well. I want them working 40 hours a week. When you have too much time on your hands, you get self-destructive, man. You just need to occupy your time, make your money, and just move on. Don't have contact, don't have any weapons, and then we're cool. All right?
Your Honor,
You got this.
respectively, due to the nature how it's continuously picking up the same complaint, we would also request GPS monitor to reflect the felony who have GPS monitoring on that for the same reason.
He has a GPS
So
monitor right now.
we want the bond conditions here to reflect that as well.
Is it through the felony court?
Yes,
Okay, so TAC Rs, you've got it on anyways. So know your every whereabouts. Don't go near these people. You got to charge it every single day, Mr. Warren. If you don't charge it, the battery's going to go dead. So does the bond. You understand? Okay, man. All right. Thanks.
Right this way.
No. You're okay. What's going on? Hi.
We're on a Treadwell. This Treadwell is in the jury box. There's a few things to address, Your Honor. There is a bond violation currently right now, and we of course want to address that. I believe it occurred on the 19th of January. Her being, I think, either 14 or 17 minutes late, I guess the curfew. And so when I spoke with my client on this, she explained it as far as what the situation was. This was the Friday right before the big snow, and everyone was going crazy. Of course, we all anticipated like it was going to be the last freeze. So she went to the store to be able to get supplies and load up on all of the necessaries as everyone felt they should. And of course, the stores are crowded. Traffic is everywhere. Prior to going to the store, my client took her 3-year-old daughter to her 70-year-old aunt's house. And the reason being is because, one, her daughter is special needs and she just does not do well in the social setting. And recognizing that it was just craziness, she had to take her there first. Lines are long, everything, once she leaves the store, it's apparent that, she very well may not be able to make curfew, but she did have to go get her daughter.
So we only have the one violation at 7:15.
That's correct.
Is that it?
That's it.
Okay. Come up, Mr. Treadwell. Ma'am, it's not the end of the world. I get it. But bond conditions are bond conditions, and you have 2 open DWIs, and you must understand that you and I are operating under strict compliance. I will give you a pass now. It's not going to happen again, though. Do you understand? Okay. All right, counsel. You're good to go.
The other matter, Your Honor, we did also want to approach on the court's consideration, or more so reconsideration of the recommendation for inpatient treatment. Now, we visited this previously.
Correct. And every time I deviate from said thing, we end up regretting it.
And
10 times over. So
you shared that with us last time. I do understand that. I at least want to do my client a little justice and at least give him some reasoning behind why we believe outpatient would be a little more appropriate. So the first thing is my client, she has been sober for 103 days. She has exercised diligently and staying committed to sobriety. While she has been released, she has been regularly attending AA meetings, meeting with substance abuse counselor who just had a home visit with her a few days ago. She has obtained her health insurance, which was previously lost due to the loss in employment, but now she can further recovery by taking advantage of the psychiatric care, therapy, and whatnot. And two, and this is really primary, it's the family circumstances. The circumstances of the family are the type that requires my client's presence at home. She is the caregiver primary caregiver of two daughters, ages 10 and 3. The 3-year-old, as we shared before, is a special needs child. And when she was in custody after the second offense, it was her parents who did take care of the children. It was,
But luckily we have that going.
well, yeah,
Have someone to watch the kids.
yeah, and that was for just about 30 days or so. Definitely operated as a hardship as the parents. And of course, in these kind of situations, there's going to be sacrifices. Sacrifices has to be made by all parties. But we're talking about now 180 days, 6 times that amount, which, again, I think it would be a tremendous hardship. And particularly with, I think a lot could be said about it, but particularly with the special needs child, what we do know about that demographic is they need routine. Routine is key in their lives. If that is removed, it's, they could get discombobulated and it could operate as a crisis to them. So what we do know is if she does have to go to this outpatient program, home is no longer going to be there. They're going to have to move with whomever.
You say she doesn't have health insurance?
Oh, she does. She does now. She obtained it as of July 31st. July 31st, right? Yes. I'm sorry, January 31st. Excuse me. But yeah, so they would have to move. They would have to switch schools, just uprooted from the life that these girls do know and understand. And again, particularly with the special needs one, possibly not even be able to attend. Is it occupational therapy? Occupational and speech therapy. Thirdly, Your Honor, when early on in this case, I had acknowledged, I had informed the court of my client. She is prescribed Adderall, and at the time of the offense, during the time of these offenses, her therapist had, they were adjusting her meds, even had her on an extremely high dose of Adderall. And I don't want to portray myself as an expert in this at all because I just found this information out, and that is that Adderall with alcohol, of course, that's a bad idea already. Okay, but what it does on a molecular level, they're both fighting for enzymes, and the enzymes are what's extracting it, getting it out of the body. The effect is that they mask each other, and so someone that is drinking while on Adderall, they're not feeling the effects. They're drinking and drinking. Your body is not telling you, okay, hey, we're intoxicated, but all the while, of course, the blood alcohol levels are through the roof, even to a fatal level in some instances. The blood alcohol levels here they're up there.
How high are we talking?
We're talking high, Your Honor.
Yes, Judge.
Yeah, no, and I understand, and that is
You realize that most people at that level, 0.4 is dead,
that's right.
right? You're at a 0.4, you're dead. A normal person at 0.3, they'd be passed out 3 times over, right? It's to be able to get to that level at a 0.3 and then a 0.2 on that truly tells me that there is an issue there.
Well, absolutely.
And me, with that kind of levels, right? And we have 2 open DWIs. If I don't follow the recommendation, because that's why we have these people. They're clinicians. They're experts in what they do. They make the evaluation. They make the choices. I understand it will create a hardship, but sometimes that's what needs to happen to gain perspective and to gain knowledge. I understand your plight. I understand your position. Every time I deviate, you regret. She has a 0.3 and a 0.2. What was it? a 0.28 and a 0.3 on two different DWIs.
That's correct, Your Honor.
I'm sorry.
Well,
Just,
you know, and again, I know that
I
that is
understand.
directly
I'm never going to be
attributed
such a lawyer for, zealously advocating, and I appreciate it. And, you have to do what you have to do. I understand. Sorry. It's too much. If it was a 0.4 or a point, 1.4, but we have a 0.3 and then we have a 0.28. Really, it's too much. I don't know how you want to move forward, but I am sorry. I don't want to deviate from it. We can give you time to make arrangements, but I think that that's the appropriate course of action. I'm sorry, Ms. Treadwell, because there are consequences to actions, right? And I know that it's going to be hard, but I think it's going to be all for the better.
Your Honor, I absolutely agree that, when we're talking about treatment, who can speak against that? And I do understand that.
And I mean, we're giving it to you for free. You get out there, you're going to have to pay for it on your own. You're going to end up thousands and thousands of dollars to pay for it. I can't pay for treatment on the outside. I'm telling you, I know that you have insurance. Insurance is only going to cover a portion. When you go to these outpatient treatment programs, they're thousands of dollars.
There is also the KEYS program and the Access program that, not really.
No, she's a 0.31 and a 0.28. Really, that needs a lot. That's why they recommended it. And I'm sorry, but I wish I could make a different decision, but sometimes we have to make tough decisions as well, and I'm sorry, Ms. Treadwell, but I will give you as much time as you need to make arrangements, but I truly think that that's the best and appropriate course of action. Okay.
How much time?
I mean, your first case is the second case is 104 days. The first case is 153 days. So you've got some time, but I mean, we're running up against it. I'll give you another 30-day setting. That's it.
Your Honor, would we bid in 45 days? Because there's going to have to be some major movement that is done on her end to even try to get someone and make arrangements for the
I will give it to you, but that's it. I mean, really,
No, I get it.
at the next setting, it's player trial. I'm not going to play this game. I will give you the 45 days, but everything needs to be done by that time. Okay? All right. Sorry, sir. Please.
We have a plea on Mr. T.
So Judge, at present, Mr. Jones has both a scram device on and a GPS, and he's on a curfew. He's broken curfew a few times, Judge. If you look at the times, though, it's because he's leaving a little early and getting home a little late. The latest maybe being half an hour past curfew. Mr. Jones has maintained gainful employment. He's worked as a helper for a transport company. He's not driving, he's the helper. And so he gets on the truck with the driver, he helps, and then they get back to their site. His wife picks him up from work, and then they pick up their grandkids, and then they get home. He's driving from the east side of town, across the ship channel, down 610 West, and then all the way to 90 into Crosby. It's a long commute. And so due to all that, and his employment is working with him right now. So they typically wouldn't be done at the times they're done, but to keep him on, they're trying to make sure he's done by a certain time so he can make curfew, but it's just a tough commute, especially when he's not the one driving and they have to pick up children because there's only one person that can drive. But he is only late and he only leaves early because of work. That is his only.
You have to understand, you have 2 open DWIs, so it's absolute strict compliance. I never want to ding anyone for working, right? I want you to work because I think that, you need to work. Number one, you need to make money, and it gives you something to do so you don't become more self-destructive as it is. I see I see the violations. We have no alcohol violations, correct? Okay, that's good.
Joshua or?
Joshua Jones, do we have any alcohol violations?
I have no problems now, Judge. Trust me.
I don't see any previous violations, Judge.
Okay, so it looks like most of the stuff, I would tend to agree with you that, you know, upon further inspection, it looks like it may be a little bit here, but there, but prior to. Is all this work related?
So
Okay, so what time do you leave for work in the morning?
I normally have to be to work at 7.
Okay.
Most times,
Because I have here that you leave one time here at 5:56 in the morning. So why that early?
like I say, most times is anything that I'm leaving is work related. And one of the things that I've been trying to do since I got out was maybe to get in contact with my lawyer to kind of help me out and
But you're not getting in touch with your lawyer at 5:56 in the morning?
But just because it's a transport company, those jobs have different timelines. They are aware of the circumstances, so they try to tighten up on those timelines. But if they have a job and might need him one day at 6:30 or something like that, that's when he'll have to leave early. And he's afraid he's going to lose that job if he can't comply with what they're asking of him. So I'm asking today, Judge, if we can loosen the timeline a
I'm
little
okay
bit.
with tweaking the schedule.
Okay.
But I want to do it in I'm not going to give you too much leeway. We have to be reasonable about it, right? So I need a time that that's early enough that, you know, you're not going to violate anymore because I don't want to continue to do this, right? So what is a reasonable time in the morning for you to leave?
if he would have asked me to get to work between 6 and 6:30.
How far is it from home to work?
It's maybe a good hour, 10 minutes if it's bad traffic or weather.
What about coming back home? What's a reasonable time? I'm not going to do 9 o'clock. I'm not going to do 9. I don't want you out that late. I will give you a little bit of time after 7 o'clock, but 9 o'clock is too late. When you're coming home here now, you're coming home at the latest at around 7:30. You know, I'm willing to give you, 7:45, 8 o'clock, but that's the latest I'm going to give you.
8 o'clock is fine.
Okay, so Jillian, we'll tweak it 5 in the morning to 8 at night. If there are any more issues, I'm going to lock you up. I mean, I'm working with you now. There should be no more issues. I want you to work. I just don't want you drinking, and I don't want you out in the middle of the night because nothing good happens out in the middle of the night. And I definitely don't want you driving. Do not drive. I don't care what circumstance comes in your life. Do you understand? I'm really going to hit the roof if you drive. Okay. All right, Jillian.
Thank you,
You
Judge.
got it. All right. Good luck, Ms. Jones. Thank you. Deputy Miranda. Hi, guys.
Good morning, guys.
So you said it's on.
Alani Gonzalez.
So we go ahead and bring this person up.
I'm sorry.
Bring him up.
Yeah, you can. Alani Gonzalez.
Do you mind bringing him up, please?
It's a lady, a girl, or a young adult. Yeah, no. Thank you. I'm trying to hide my little.
Because you got this issue.
Exactly.
All right. Are you Miss Alani Jones? I'm sorry, Alani Keontae Gonzalez.
Yes, yes.
Miss Gonzalez, your lawyer's asking me to set you a bond. You are a fugitive from justice. There's another state that wants you. I don't know why. I know that you're going to tell me it's little bunnies jumping in the woods but I have to get to know you in a very short period of time. So please, let's get to meet Miss Gonzalez.
Your Honor, Ms. Gonzalez is one out of the state of Louisiana, specifically Baton Rouge Parish, for 2 offenses, the first felony larceny and the second monetary instrument abuse. I don't see that there's a bond there. She has no holds out of any other jurisdictions, Your Honor.
Any other criminal history? Okay, how old is she? How old are you, ma'am?
23.
You're 23?
And Judge, yes, that is true. She has no criminal history. She is indicating to me that she lives in Houston. She works in Houston. She has no recollection of even going to this parish. I've explained to her that you will give her 14 days if you give her a bond to go down there and settle this matter. We have no information about the case that we can give to her. She needs to go to Louisiana and handle that. She understands that. She's never been in trouble, never been in jail. She's asking for you to set her a bond so her family can bond her out and assist her in getting to Louisiana to address these issues.
I'm okay with giving her a bond. I mean, it's nonviolent. I don't have any, significant criminal history.
I'm not opposed.
So the next question is how much? Amy, guys, what do you say? What do you think?
Stations are unopposed to a bond, but we'd be opposed to a loan. Maybe like 5,000.
I'll ask for $1,500. She's 23 years old. She works at a bar on tips. Her family is willing to assist her. But I do believe that based on that information alone, that she's willing to do the right things, go and report back because she knows that you will issue a warrant for her arrest and bring her right back in the event that she does not obey these court's orders.
Ms. Gonzalez, you need to understand.
As a 3-year-old, she wanted me to.
You need to understand that these are serious charges and we take these really, really serious, If you want me to set you a bond, I will. I'll set your bond at $1,500, but you have to understand that you're going to have to probably pony up all of that money. It's not the 10% deal because you're a fugitive, meaning you are a flight risk in and of itself because it's out of another state. I will give you the opportunity to bond out, but I want you to understand we don't play games here. So if from the day that you're released, we give you 2 weeks to go turn yourself into Baton Rouge and take care of the business that you have there. You have to turn yourself in. There's no bond to post there. If you fail to do that, I'm going to revoke this bond. I'm going to set it at 0. I'm not going to give you another one. So if you fail to do it, I'm going to get you back because you can't run forever. And this time I'm going to hold you in custody until Baton Rouge comes and picks you up.
Okay.
You understand?
Yes, sir.
Okay. All right. So we'll set bond at $1,500 and then.
I will add she's waived, so she can mean she or withdraw and waiver today.
Okay. So she did waive.
Correct.
Have you spoken to any family members to make sure that they can make that bond?
No, Judge, I have
Okay,
not.
so the deal is this, is that, we give them 14 days to come pick you up, 14 days from the day that you waive. When did she waive?
Yesterday.
Did you waive today?
Yesterday.
Yes, so you have 1 day credit toward that 14 days. When you have to withdraw that waiver to be able to bond out. You lose that 1 day credit. And so that's why I would like, prior to you withdrawing that waiver, let Shabli reach out to your family to make sure they can make that bond because I don't want you to lose that 1 day credit, So we can put you back once you verify, or if you don't want to, that's okay too. If you know that they're going to bond you out regardless. I don't know. Sorry?
I can go call them right now.
Well, give the number to Shabli and Shabli can call back there for you and then you guys can talk back there. Okay?
All right.
And then just let me know.
Yes,
Thanks.
thank you. All right, thank you.
So once, and if they say yes, at that point, 1,500.
Judge, do you want the other one?
Is it a waiver?
She has not signed it. She's willing to waive.
What's the name?
Her name is Jennifer Claus. She was brought in on Friday. She did not sign. The state is willing to give her the back time for it, but she has not signed the waiver yet. So I don't know if you want to admonish her.
Yeah, I mean, we have to. She's not signing it. She's not doing
Right.
it. Deputy Miranda, do you mind bringing out Jennifer Claus, please? Oh, that's a lot of history right there.
Yeah, she's not.
Oh.
She wants to wait on her train.
Prior to this.
Good morning, Ms. Claus. So it's come to my attention that you have not signed the waiver. So there's two options that we have here. You can ask for a bond or you can waive extradition. Once you waive, we give the demanding jurisdiction 14 days to come pick you up. In this case, it's Orange County, Florida. That's where you're wanted out of for grand larceny in the third degree.
For what, sir?
Grand larceny in the third degree.
That means grand larceny.
Larceny is it's a theft.
Third degree, it is.
As far as, I'm just telling you what they wrote on the actual, on the complaint, it says not grand larceny, grand theft in the third degree, $5,000. That's what it says. So if you do not want to waive, that is okay. The waiving, it speeds up the process because we only give them 14 days. If they don't come within the 14 days, Harris County releases you. You got to understand, even if we release you, that warrant from Florida will always remain active until you go back to Florida and take care of it. If you refuse to sign the form, that's okay. We will get a governor's warrant, but that takes 90 days. So you're going to sit here 90 days waiting for that governor's warrant to hit. So I will let you make the decision with Chablis, what you would like to do. I don't want you to make a decision here in front of everyone. Take your time.
She does want to waive, and they were going to give her the credit for Friday when she was originally booked in. They were going to backdate it to Friday.
Well,
Here's the kicker, though. I just noticed you have an open felony theft case, and you've not made bond on the case. So what happens is that 14 days is typically told until you resolve that case or until you post bond. When all the holds are lifted, at that point, that triggers the 14 days for Florida to come get you. So,
I didn't know you had a case. a
yeah,
local
I mean, I
case.
just noticed it too. So, you can still waive now so that once that hold lifts, it kicks in the 14 days. So, well, I'll let you guys talk about it and let me know.
Thank you.
All right.
Okay, I'll get the paperwork to you. It just doesn't come into effect until you handle the paper.
So Chablis, if she waives, there's no need to bring her back out. We'll just sign it and then I can sign it and then we're done.
Yes, sir.
That's fine.